So the common scenario for signing an NDA is that two companies are considering doing some form of commercial or corporate transaction between one another, and they need to disclose some information in order for each of them to evaluate the potential transaction. And then the day comes around when they've decided to enter into the transaction. They've negotiated a contract, and the question sometimes arises, do we need additional confidentiality provisions? Do we need an NDA-like section within the contract if we've already signed a non-disclosure agreement? Well, the answer is it all depends on what the non-disclosure agreement says and what the contract says. I wish it were an easier answer to that, but there are a few things that I can tell you to look out for. Oftentimes in the final contract we'll include a provision, almost always, which we call a merger clause or an entire agreement clause, saying that these terms in the four corners of this document are the entire set of terms and conditions that relate to all the subject matter that's discussed in that agreement, including perhaps the exchange of information. And if that agreement does not include confidentiality provisions, it might be considered by a court to supersede and therefore nullify the prior non-disclosure agreement after that agreement signed and with respect to information that is disclosed under the final agreement. So it is important to make sure that you are protecting it in some way, and you might be able to do that by, the simplest way of course is just to include all the appropriate confidentiality provisions in that agreement, or you may be able to include a statement that says that prior NDA is incorporated by reference into the final agreement. But a word to the wary there, you need to look at the previous NDA and make sure that its terms are appropriate for the final agreement. There are several reasons that they might not be. That NDA may limit the purposes for which information disclosed under it may be used. It might, for example, limit the use of that information to consideration of an eventual transaction. It might limit the disclosure of that information to only a handful of individuals, for example, and that might not be appropriate in the final business relationship. Or that agreement might contain sunset provisions that say, hey, within 3 years of disclosure or after that term expires, information can be freely used, even if the commercial agreement is expected to endure longer from that. Or worse yet, the NDA might say that it has a set term limit, let's say a year, and an ambiguity is then created under the final contract that says, well, a year into that or a year after the original agreement was signed, are there any protections in place? Now, this doesn't often pose a problem, but you should consider whether there are inconsistencies between those limitations or exceptions in the NDA or expirations of protections in the NDA, and what the purposes are and the duration of the final contract will be.